Good morning, everyone, and welcome to the webinar, Medicaid Appeals and Reconsideration. I'm Dana Casserly with the Pennsylvania Health Law Project, and joining me on your screen are your two presenters for today's session, Pam Silver and Jake Lee, both attorneys with the Pennsylvania Health Law Project. Today's session is the third in a series of webinars we're hosting this spring on Medicaid and the public health emergency unwinding. Throughout the series, we're providing practical tips and information to help you or your clients or your patients maintain Medicaid coverage after the pandemic ends. So that will have, now that the pandemic is over, the COVID era rules are no longer in place, and we're going to see some changes with how things are handled in the Medicaid space. At the end of the presentation today, we will share the upcoming trainings that we have scheduled in this series, along with the registration links. And those links to register are also on our website at phlp.org, and they'll be in the slides that we're going to circulate after the session. So just a bit of housekeeping before we get started. If you have questions for Pam or for Jake today, please type them into the Q&A box in your Zoom control panel. Try to avoid putting questions into the chat box. With so many folks on today, it will get pretty crowded quickly. So use that Q&A box for your questions, and we'll stop periodically during the presentation for questions. And we'll do our best to get to as many questions as we can while being respectful of our 11:30 end time. If there are questions we can't get to, there will be contact information on the final slides. You can reach out to our helpline or contact the presenters to discuss issues that come up. If you have any technical difficulties during the webinar, please first try logging off and logging back in to see if that fixes the problem. If that does not resolve the issue, please email event@phlp.org. That's event@phlp.org. The presentation today is being recorded, and a copy of that recording, the slide deck, and some handouts that we'll talk about today are going to be sent around after the webinar. Closed captioning is available for today's session. To see the closed captions, click the three dots in your webinar control panel, and then click Show Subtitles, or sometimes it shows up as Show Captions. If you're seeing the subtitles and you want to disable them, click those three dots again, and then click either Hide Subtitles or Hide Captions. So with that, I will turn things over to Pam, who's going to get us started today. Go ahead, Pam.
Hi, everybody. If you can't hear me, do send a quick message so that I can fix that. It's a pleasure to be here. So today we're here to talk about Medicaid appeals and reconsideration. Hold on one second. So first, just a little bit about PHLP. We are a statewide nonprofit legal organization focused on helping folks access and keep Medicaid benefits. Some of the things we do are our helpline. We offer free legal services for Medicaid participants across Pennsylvania. We do community education and trainings like this one. We have our excellent monthly newsletter, which I encourage you all to sign up for to keep up with the latest news. And we do policy advocacy. So before we get started, I have just one quick poll question to help me understand who's with us today. So if Dan, if you would launch the poll, our first question is, what best describes your role dealing with Medicaid and Medicaid recipients? Are you an attorney for a legal aid organization? Are you a paralegal or another type of advocate? Do you work as intake or support staff? Are you a Medicaid participant or healthcare provider? We give folks a minute to respond. Okay, and it looks like we've got people from all different backgrounds, so it's great to have you all here. So what we're going to cover today is, first, we'll do just a quick recap of the COVID-19 and Medicaid continuous coverage to set the stage. And then we're going to focus on how to troubleshoot when you get a Medicaid eligibility denial. Then Jay's going to talk to you a little bit about reconsideration, about fair hearings, and we'll finish by sharing some helpful resources. So first, just a recap of why we're here today in this Medicaid continuous coverage. So I'm sure everyone's aware, we've just been through a pandemic. And since early 2020, we've been under what's called a public health emergency. And as part of that public health emergency and the Families First Coronavirus Response Act, we've been operating under what's called Medicaid. So as part of the public health emergency and the FFCRA, Congress gave states a boost in their Medicaid funding on the condition that they maintain people on Medicaid for the duration of the PHE. And that includes any folks who were enrolled in Medicaid as of March 18th of 2020, which was the early days of the pandemic. So for the past almost 3 years, Pennsylvania has not been kicking people off of Medicaid, except for very limited circumstances. That's over now. So as of April 1st, 2023, the Medicaid continuous coverage protection has ended in Pennsylvania, and DHS is now allowed to begin kicking people off of Medicaid again under certain conditions. So they're not going to be reviewing everybody or trying to go through all those people at once. Instead, they're going to be reviewing all of this, what's called the COVID maintained population, over the next year as part of their regular renewals of the entire Medicaid population. So they're going to be reviewing a little over 300,000 Medicaid beneficiaries every month. The key takeaway here on this slide is that for folks who have been maintained on Medicaid because of the pandemic, they have to have a full renewal before the county assistance offices can start terminating them for being ineligible, even if there's been a change in circumstances. And I want to refer you folks to this operations memo 23-303 that goes into a lot more detail about all of that procedure. So this slide just sort of illustrates some of the communications participants are going to be getting as their renewal date approaches. And you can see they're going to be getting a number of reminders both before and after the renewal is due. And renewals are underway now. The first renewal notices were sent in March 2023 with April due dates. And as the counties process those renewals and determine eligibility, they will be able to terminate people. Again, they're not going to be going through the entire population that's been maintained on Medicaid at once. Most folks are going to get their renewal when they normally would have gotten their renewal before the pandemic. So if before the pandemic, a participant typically got their renewal in August, they should generally be expecting to get their renewal starting in August this time around, and their Medicaid will stay in place until then. A quick note on that, they still have a duty to report changes in their circumstances. So if someone wins the lottery, they get a new job, they get an inheritance, anything that potentially changes their eligibility, they still have a duty to report that, just like they always have, but the county assistance offices are not supposed to be acting on any of those changes for that COVID maintained population until they're normally scheduled for renewal. Now, I imagine people probably have questions about this. I'm not here today to really go into all the in and outs of the renewals and how it's going to work. I would encourage you to check out the recording of our webinar that we just did a couple weeks ago that goes into a lot more detail about this, and also skipping back a couple slides to that operations memo. If you have questions about that, and you can always call us for questions, but I'm not going to go into much more detail about the renewal process or unwinding. Instead, what I'm going to focus on is what happens after the renewal when a participant gets a termination notice saying their Medicaid is being stopped. Well, I'm going to talk about how to troubleshoot that. So first, I have another poll question for you. And this question is just asking how much experience or what's your level of experience working with county assistance offices? These are the welfare offices that review Medicaid applications. So if you work for a legal aid organization, you might be working with county assistance CAO staff all the time on behalf of participants. Or you may have contact with them as a participant, or you may not have any contact with them. So I appreciate sharing with this poll so we can get a sense of how much experience folks have working with the CAOs. Okay. All right, so we have a good amount of people who don't have a whole lot of experience working with CAOs. All right. So how about the next question? Do you have access to what's called EVS, or the promise system, through your organization? So EVS is a system that allows you to verify or check a participant's Medicaid eligibility. And it might show you some information about what Medicaid category they're in. If you haven't heard of this, then you may be wondering what it is, but I'm going to refer to it a little bit for those of you who have heard of it. Okay. All right. So it looks like some folks have worked with it and a lot of folks haven't. Okay. Thank you for that. All right. So just to refresh your memory on what are some of the procedural requirements before the CAO can terminate someone's Medicaid. The first thing you need to remember is that they must provide written notice, right? They cannot just terminate someone's Medicaid without giving them advance warning. And in the case of this unwinding period, when they may be taking action to terminate benefits for folks who have been on Medicaid already, that notice has to give advance warning. So in other words, the notice can't have a mail date and say, you know, your Medicaid, your medical assistance benefits, you're no longer eligible effective today. It has to give a date at least 10 days in advance. And this is required under the PA code. When a participant gets this denial notice, they have 30 days to appeal by requesting what's called a fair hearing. And Jake's going to go into a lot more detail about that. For our purposes right now, the important thing to keep in mind is even though they have 30 days to appeal, if they want to maintain their benefits and keep Medicaid in place while they're going through the appeals process, they have to request that appeal within 15 days. In other words, if they appeal within 15 days, they will continue to receive Medicaid during the appeals process. This is called aid paid pending. If they miss that 15-day window, they still have some time to appeal, but their benefits will be discontinued while they go through that appeal process and won't be reinstated until they, until they finish their appeal. The fair hearing can be requested by mail using the form provided with the denial notice, or it can be requested verbally, but it has to be reduced to writing within 3 days. So in other words, you can call the county assistance office or call the number on the fair hearing request to let them know that you're requesting an appeal, but you want to get that form in the mail as soon as possible. So what are some reasons that a person might have their Medicaid terminated? Well, the biggest scenario we're concerned with during this unwinding process is folks whose benefits are being terminated simply because they didn't get their renewal packet in on time, or they didn't provide the income or resource verification documents that the county assistance office needed. As part of the renewal process, the county assistance office may need additional proof of income or resources to review their eligibility. And if participants don't get that in on time, the county assistance office can start terminating the benefits. There's a special process for dealing with this called reconsideration that, again, Jake's going to be going over with you in a little bit. For folks who did get their renewal packets in on time, some of the reasons that they might be, their Medicaid benefits might be terminated incorrectly could be due to, the county assistance office relating on outdated income or resource information. It could be because they're using or relying on income or resources and including that as part of the calculation when it should be excluded. They could be including people as part of the household size that shouldn't be included, and that can cause them to apply the wrong income limit. They could be not applying appropriate income disregards or not reviewing them for alternative categories of Medicaid. And so, you really can't take just because the county determines that someone's ineligible, you can't take that at face value. There's any number of ways that the county could mess this up. The good news is that in a lot of cases, this can be resolved before the hearing by sort of informally reaching out to the county assistance office and providing additional or clarifying information to resolve the hearing. And I'm going to talk more about how to do that. So the first thing you want to do when a participant comes to you saying, what gives? I got this notice saying my Medicaid has been turned off. You want to see if they've appealed, right? If they're within that 15-day appeal window to get aid paid pending, you want them to get that appeal in within those first 15 days so they can keep their benefits going during the appeal process. Even if they're still within the 30 days, you want to make sure that if they're still in time to appeal, that they do. Then you want to take a look at that termination notice to see if there's any problems with it. First of all, did they even get a written notice? In some cases, especially if you're a provider, you might be the first person who finds out that their Medicaid benefits have been terminated when they're calling you about a bill, or when you're running their insurance at the check-in counter and it turns out their Medicaid's off. Did they get a notice? Did that notice provide 10 days advance notice, or is it trying to say that your benefits are discontinued effective today? Does it give any reason for the denial, right? It should be explaining that your Medicaid, you are no longer eligible for medical assistance because, for example, your income is too high, your resources are too high. But occasionally we've seen a notice where all it says is something like, you are no longer eligible for medical assistance because, and then gives no explanation whatsoever. That's a problem. Or the notice might not provide any information about what income or resources they're using. So if they didn't get a notice, or if there's problems with the notices, I'm going to talk about in a minute what to do about that. Assuming there isn't a problem with the notice and they got one, the next thing you want to do is check whether the county assistance office made the right decision, right? Do your own review of the Medicaid eligibility. And if you're not familiar with the ins and outs of Medicaid eligibility, I highly encourage you to check out our excellent webinar we did just a couple weeks ago to refresh yourself on Medicaid eligibility. So when you're doing this, some of the things you want to look out for is the county assistance office using accurate income and resource information? Usually it's the second or third page of the denial notice will list the income or resources that they're using. Did they get it right? Are they using an income limit that seems to be out of sync with what it should be for that person's household size? Are they applying applicable disregards? One problem we see occasionally is that it'll be a participant who's in mod, but they're not applying earned income disregards like they should be for mod. Or they didn't review them for mod or any other category like they're supposed to, right? The county assistance office is supposed to review participants for all Medicaid categories that they're potentially eligible for before taking steps to terminate them. But a lot of times they might miss things like some of the disability related categories, especially if there's nothing in the application that sort of alerts them that this is a person with disability. So that could be mod or PH95 is where we see this coming out. If it looks like the person is being inappropriately found ineligible, then you want to get together any additional information that might be needed to establish their eligibility. So that could be proof of employment if you're looking at mod, or if you're looking at mod or PH95, those are Medicaid categories. You might need documentation of their disability. Or you might need provided updated pay stubs or bank statements showing that, in fact, their income and resources aren't what the CAO is seeing. Whatever additional information needs to go in, you want to get that to the CAO and just get it on its way. And I'm going to have some tips and tricks about how to do that in a minute. Once you've sort of gotten the information you need and confirmed for yourself that you think they're eligible, the next thing you want to do is try to reach out to the county assistance office if you can to try and resolve the appeal before the hearing. Like I said, a lot of times just by going through the eligibility information with them, you can get them to fix it, and the hearing becomes unnecessary. There are a number of ways to get connected with the county assistance office. The best way, if you have a direct contact with someone at the county assistance office, is to go through them. Or if, for example, the participant has already been in contact with them and they they have a case handler's name, you can try contacting them or contacting the county assistance office directly and asking to speak with that person, and setting up a conversation with that way, or scheduling a time to talk to them. If you don't have a direct line, you can try calling the statewide customer service center and telling them that you'd like a pre-hearing conference to discuss trying to resolve this appeal, and ask them to have the case handler reach out to you to go over this. If you're able to get through to someone at the county assistance office, what you're trying to do is you're really just using that opportunity to kind of explain why you feel that the person actually is eligible for Medicaid. And the action you're asking them to take is to resolve the pending fair hearing by restoring Medicaid or authorizing Medicaid in a different category. So that's the conversation you're trying to ultimately have if you can. Now, a word of warning about this step. We're not entirely sure how responsive or how accessible the county assistance office caseworkers are going to be during this unwinding process. I know sometimes we have a difficult time getting a hold of them even before the pandemic, and right now they're going to be dealing with a heightened volume of potentially a heightened volume of appeals, and they're still significantly understaffed. So that is to say that I would advise participants to try and be patient, give the county assistance offices a reasonable amount of time to do their job. And, you know, I certainly wouldn't be advising participants to be calling the county assistance office or customer service every day, hounding them. Give them space, especially if continuing benefits are in place. You know, you can give them, you know, try and be patient with them. And there is a risk that you may not be able to get through to them before the day of the hearing. And if that's the case, you still have an opportunity to have a pre-hearing conference at the scheduled hearing time. And that's maybe what you have to do. If you are successful at getting through the county assistance office and they agree to withdraw or they agree to reinstate benefits, then they will issue an eligibility notice confirming that the participant is now eligible for medical assistance. And once you get that, or once you get at least something in writing confirming that the benefits are going to be reinstated, you can go ahead and withdraw the fair hearing. If you aren't able to get through to them before the date of the hearing, then you may have to just use the hearing time for a pre-hearing conference and straighten it out with them then. Or worst case scenario, present your case to the judge as to why you think they're eligible. And Jake's going to go over fair hearings more in a minute. Okay, so some of you may have been asking yourselves a couple slides ago, well, hold on a second, what if they didn't get a notice? Because the second thing I asked you to do is take a look at the notice. So a scenario where this might arise during the unwinding process could be if the participant moved at some point during the pandemic and didn't update their address with the CAO. If that happened, then all the renewal paperwork, termination notice, that might have been sent to an old address. And so they may not have gotten notice about that termination late if they got it at all. If this happens to a participant you're working with, you want to have them file a fair hearing request if it's not too late, right? Especially if they're still within that 15-day window to keep their benefits going. And then you want to try and get a hold of the county assistance office and get a copy of that notice, right? Or talk to customer service, see if they can confirm the date that the termination notice was sent and where it was sent, or better yet, get a copy. If there was not a notice sent, if they did not send a termination notice, then they can't terminate the benefits, and they should be reinstating the benefits immediately back to the date of termination and keeping them there until they go through the appropriate channels to start terminating benefits. The more likely scenario is that the CAO or the county or the customer service will be able to tell you, oh yeah, a notice was sent on this date. And if you can, but then you find out that the address they sent it to was wrong. If this is the scenario, then it's a little trickier, but what you can try and do is have the CAO treat the notice as defective and ask them to just rescind it, reinstate the benefits, and reissue a termination notice as if they'd never sent a notice at all. Or you can, or at least try asking the CAO just to reinstate the benefits while you wait for the hearing and try and resolve it. If you're completely outside of the appeal deadline, you might still be within the window for reconsideration, and Jake's going to talk more about that. And it goes without saying, if they didn't get a notice because of an outdated address, have your client update the address now, either through Compass or the statewide customer service center. You don't want this to keep happening. Okay. What about step 3 of the process? When I talk to you about doing your own eligibility review, well, what if it looks like the county assistance office got it right and the person is in fact no longer eligible for Medicaid? this could very well, we could see a lot more of this during this unwinding process because there are some folks who really have only been maintained on Medicaid because of the pandemic. So if after carefully reviewing and re-reviewing their eligibility, you determine, no, they're not actually eligible, they shouldn't appeal, or they should withdraw their appeal because it's no longer necessary. You don't want to, waste anybody's time any further by pursuing an appeal when you know they're not eligible. The other reason that you want to withdraw the appeal once you're certain that they're not eligible is because in theory, they may be subject to an overpayment. In other words, the Department of Human Services might try and go after the participant to recoup their costs for that period between when the person filed the appeal and when they were found to be ineligible. This is technically a risk, although in practice we've only seen this once or twice, but it's still a theoretical risk. And more importantly, it's just not a good use of anyone's time to continue appeal once you determine they're not eligible. I will say that the person is not subject to overpayment for any benefits they received during the PHE, even if they were ineligible. So they don't have to worry about the state going after them for if they've been ineligible for a couple of years now, but been maintained because of the pandemic. They don't have to worry about the state going after them for all of those Medicaid costs, right? And I've attached some guidance from CMS that explains that in case you need more information about that. So you can reassure them that they don't have to worry about the state going after them for all of that. If the CAO is determined that they're ineligible, they should be referring those people to try for marketplace coverage. That's Penny, is Pennsylvania statewide Medicaid. And I think the Medicaid 101 webinar we did talks a lot more about that. There's a 60-day window, special enrollment period for folks to get into a marketplace plan after losing Medicaid. And for kiddos, they should be getting referred to CHIP. All right, I talked a lot about submitting documents to CAO, and this can be tricky sometimes, but there's a number of ways to do it. Obviously, if you're tech savvy, you can use Compass or help the participant upload it into their Compass account, either through desktop or on a mobile app. You can get together the documents and mail them or fax them to the local CAO, or the participant can take them in person to their local county assistance office. And there's a link here with all those addresses. The termination notice will also have the county assistance office address that they should be using. So I got some tips and tricks for submitting documents. First thing, wherever possible, you want to send it in a way where you have a receipt or tracking. Send it by certified mail if you can, or if you're faxing, get a fax confirmation page confirming when you sent it and that it went through. If someone's taking documents in person, encourage them to ask for a receipt, a time-stamped receipt, a date-stamped receipt. Never, ever, ever give the county assistance office your only copy of something if you can help it. Always encourage participants to try and make or keep a copy of everything they're sending. And this is mostly for mailing. If they're faxing or uploading it to Compass, they're not going to be submitting it. But you don't want to lose the original copy in case you need to resubmit things. Make life easier for the county assistance office by including a cover sheet. And make sure you include some, and I've listed here some information that they should include on that to make sure that they can connect it to your case. If you're faxing or uploading to Compass, make sure you're scanning both sides of the page. This trips me up all the time. Make sure you're scanning it on both sides. And then a helpful tip for folks who need somewhere to fax or scan the documents. There are some libraries or actually even state representative offices who will fax documents for free for library patrons or for constituents. So if they need if they can't afford to take the documents to Staples and pay by the page to fax it, maybe their local state representative will fax Medicaid applications for constituents. So with all of that, are there any questions?
Thanks, Pam. We do have a handful of questions in the Q&A. And I do want to know, I fielded a question about how to enroll in the EBS or Promise system. And I put, for folks' reference in the chat box, a link to the DHS website that has information about how to enroll in Compass. So I think that's the best path for people who are interested in doing that. But Pam, the question that we got, first we have a question from Peter, who's a PA Medi counselor. Is the appeal process the same for beneficiaries who are enrolled in the PA Life program?
That's an excellent question. You're asking if the appeal and fair hearing process is the same for people who are in PA Life and potentially being terminated?
Right. I think the question is, would it be the same,
Okay.
Renewal and then potential denial and then fair hearing if it's for life benefits?
That I do not have the answer to that question, but I think you might check out our previous webinar about the unwinding or that ops memo. I think there might be a section in the ops memo that I included that might specifically deal with life.
Okay.
And if you can't, and if it's not there, please feel free to send me an email and I can do more research for you.
Okay. And just for folks' reference as well, I'm going to put the ops memo in the chat. I just started uploading some handouts to the chat. I'm also going to send all of these by email, but just so if folks want to see it now, I'll get the ops memo in there once we're done with these questions. And then two questions that are along the same lines about the 10 or the 15-day notice, the deadline to appeal. So does it include the mailing time? Both of the question askers here are saying that they're seeing a lot of clients who get their notice the day before the deadline or even days after the deadline. So what can they do in that situation?
Sure. So, and this is a very good question. So I believe the controlling date for that would be the mailing date on the notice. So if a participant gets their denial notice just a couple days before the 10 days is up, they still have time to appeal. They should phone in their appeal and follow up with the written fair hearing request and make it clear on that fair hearing request that they're following up from their call. If they get it after the window for continuing benefits has closed, I would suggest trying to reach out to the county assistance office, explain the situation, and see if they're willing to reinstate the benefits pending the appeal. It's possible you may not be able to get through to them, but do your best to try. And feel free to reach out to us if you need technical assistance on that. I hope that answers your guys' question.
Thanks, Pam. I would also add, if folks get a notice that has, it's come late, the deadline's already passed, save the envelope, because it's possible that you'll see that the envelope shows that it actually was postmarked 5 days after the printed mail date on the actual piece of paper that's in the envelope. So you can sometimes use that to show that by default here, this clearly was not sufficient notice and it went out too late based on the postmark from the post office on the envelope.
An excellent reminder, and definitely keeping the envelope to keep track of the postmark date is a very helpful tip when you're dealing with something that's important.
Mm-hmm. Next question from Lisa is, I have a client who has a son that's getting benefits under the PH95 Medicaid category. He turned 19 in December, but then just received a recertification packet. She's wondering if the age limit has changed, or should they assume that this packet was received in error?
So I wouldn't assume it's received in error. It could be that they're getting ready to review to see what other categories you might be eligible for before they terminate PH 95. I would go back to that ops memo, take a close look. Certainly, if you get a recertification packet, you should fill it out and get that in timely. But I wouldn't assume it's an error.
Yeah, I would agree with that. I think that the PH95 category ends at age 18. So it sounds like because he turned 19, they're going to re-review his eligibility under the adult categories. Okay. Let's see, we're getting a few more questions. Let me just parse through them. Is there any way to look up someone's CAO record number? It's listed on our CAO correspondence, but our clients often lose those and we aren't able to get through to the CAO staff when we're trying to contact them.
Yeah, this can be tricky. I would see if the person has their access card, their access ID card, or their health choices, their health choices plan ID card, and see if that has a Medicaid ID number. Try that. If you have access to EVS or Compass, if they have an EVS or Compass account, you might be able to find it through there, because EVS allows you to look them up in a number of ways. You can look them up by name and date of birth, or social security number and date of birth. You don't necessarily need a record number, and that could be a way where you can find the record ID number. So those are a couple ways you can try and find that number, because I agree that's helpful to have when you're trying to reach out to the county assistance office. But you can also see if the county assistance office can look them up by their name and date of birth.
Thank you, Kim. The client who gets a termination notice, then gets medical bills, then gets reinstated, will the benefits be retroactive back, making for continuous coverage, and therefore the medical bills could be covered? I think the question is, will there be a break in coverage, and how do you get the medical bills covered in that interim period?
Sure. So first of all, if you are able to get the appeal in time to maintain aid paid pending, there shouldn't be a break in coverage, and you should be able to, they should still be able to bill. If they missed that and it's reinstated after an appeal, I think the normal process is for it to be reinstated all the way back to the date of coverage, although you might need to specifically ask for that. And then if they're going through reconsideration, which Jake is going to explain a little more, reconsideration would have the benefits reinstated back to the date of coverage. So these are all reasons why it's important to try and make your most of the appeals process to make sure that there's no gap in coverage. I hope that answered your question.
Next question is, I have a client who got his renewal packet. He turned 65 last year. He was not asked about any resources, only his income. He's concerned because he believes resources will make him ineligible. He called Compass and they told him to just fill out what was given.
I would agree with that. I mean, I would, you can't, give them preemptively information that they're not asking for. Fill out the recertification forms as best you can, provide honest information. And if the county assistance office does need resource verification information, they'll send a follow-up letter asking for that.
I think we discussed this a little. It's sort of a tricky question, but if you have any tips, just to reiterate for folks, when contacting the CAO, do you have any suggestions for how to reach people in these busy offices?
I don't have any other suggestions beyond what we provided. Like I said, if the participant has a case handler who they've worked with, who they know a case handler name, you can try and ask for that person directly, calling the CAO directly. If you've worked with someone in that county assistant's office before, you might try reaching out to them and seeing if the case handler assigned to that case can reach out to you. Or you can leave a note through the county or through the statewide customer service center. But in terms of, how to actually get the caseworker to pick up the phone and respond and call you back, other than, if I suppose you can make it clear in your message if it's something that's time sensitive, explain that there's a gap in coverage, that they're facing bills, or that they've got an imminent hearing date. That may allow them to know that this is time sensitive. But we run into this problem too, that if they're not responding to messages, there's only so much you can do to get through. You may have to wait until the actual day of the hearing when you have a scheduled hearing time and use that for a pre-hearing conference.
Thanks, Pam. Another idea that just came to me is the publicly available DHS Telephone Directory breaks out contact information by CAO. So if you're truly not getting through to the caseworker, maybe you even tried a supervisor and they're not helping, you can go all the way up to the district administrator, which is basically like the person who runs that CAO, and their phone numbers are publicly listed on this directory. So I'm going to put that in the chat as well. And then someone in the chat also added that SHIP counselors have a list of contact people at the CAOs. So I think that would be our PA Medi folks.
Oh, great. Okay. So if you have separate contact lists that you're able to share, then by all means.
Yeah, and another person has added that they've never been able to get through to the CAO, but the statewide customer service center is very helpful. And that's that 877 number that we have on the slides.
Absolutely. And that's what, I've suggested is that, like, if you know that you just want to talk to the case handler, you can try leaving a message through that explaining that you want to have a pre-hearing conference to resolve this, and hopefully they can get back to you before the hearing date.
The next question is about waiver eligibility, about the process for waiver. So if a participant is receiving waiver, sometimes the benefits are terminated due to an issue with their functional eligibility. And once that issue is resolved, the Medicaid is fixed. Would someone have to go through all these steps of, appeal, reconsideration, if fixing the waiver resolves the issues? Meaning, I think, fixing the functional eligibility.
No, they wouldn't, because if that fixes the problem, it still might be in their best interest to file the appeal if they get a termination notice to protect that right and preserve that. But yeah, if they are able to resolve it through other ways, then they'll be able to withdraw that hearing.
Great. Last question, and then we can move on. This person has been submitting their renewals for years now, and they're never getting any notices about eligibility or denial. So they're wondering if there is a way to obtain written notification of their eligibility.
Sure. So I think what may happen is, over the course of this renewal or this unwinding cycle, you may get another renewal packet. And at that point, you would want to fill that out with updated information, and the CAO will issue a decision notice as to whether you're still eligible or not. If you are concerned about your eligibility, you can look yourself up in Compass, or just if there's, if you are sending in everything that they're receiving, that they're asking you for, and you're not getting any notice of termination, and you're not hearing from providers that there's a problem, then that may be a situation where no news is good news.
Thanks, Pam. Those are the questions we have for now. We'll stop again in a couple of slides to do more.
All right, thanks, folks. And now I'm going to hand it over to my esteemed colleague, Jake.
Pam, can you hear me all right?
I sure can.
Okay, great. What a day for my headset to fight with Zoom, but thank you guys for joining me. I'll try to keep my voice up as I'm going to use my microphone here on my laptop. So I'm going to talk today about reconsideration and fair hearings. So these are two types of ways to appeal a negative, like a termination or a change in category that you don't think that you need based on some documentation. So first, I'm going to talk about reconsideration. Pam, can you go to the next slide for me? Thank you. So reconsideration is mainly when there's a termination due to missing renewal paperwork. And we're probably going to see a lot of these as this PHE is unwinding, whether it's due to what Pam talked about missing addresses, or just missing notices in general, or people not opening their mail because they haven't had to do this for a while. So with the renewal packet or verification documents are not received by the county assistance office, they will send the termination notice. And that termination notice, which I'll get to on the next slide, will say why the person is being terminated. It should, as well as the applicable law, and as well as the issues when it comes to maybe they sent the information to the wrong county assistance office or the wrong address. So reconsideration avoids the need for submitting a whole new application through Compass. We all know that those applications can be long and they don't need to be submitted once somebody is approved for Medicaid. They only need to be renewed. So if you're doing reconsideration, and you submit the documents that were missing, you're going to be reinstated back to the date of termination. So there should be no gap in coverage when we're moving forward. Next slide, please, Pam. So on this one, we just wanted to show you kind of like, this is an old notice, but we wanted to show you what it talks about when it comes to what you want to look for on the notice. So when it says at the top that you no longer qualify for medical assistance effective date, and here's why. So they're saying that they didn't receive the information that you were asked to provide, whether it's new income verification, updated income verification, Social Security, that kind of issues. So it will tell you, and it should tell you more specifically why in that second box, and it should tell you the date that it was due by. Now, at the same time here, once you get this, you want to review it closely and get these documents together. Next slide, please. So when we're talking about reconsideration, I wanted to put in the Medicaid eligibility handbook site here as we're talking about when reconsideration is, this is going to bring somebody back, even if they're terminated. If they do this within 90 days to submit the missing documentation, the county assistance office has to give them retroactive coverage as long as they still qualify back to the date of termination, back to the date that the documents were missing and they were terminated. So when you're looking at reconsideration, think about it as kind of like an administrative, almost paper appeal, just because there were some missing documents. And this is a way to make sure that if you incur medical bills during this time where their benefits were terminated, that it will be reinstated as long as they continue to qualify. And the only reason that they were terminated was the missing documentation. So I always like to keep this site there in case you need to remind the county assistance office about what you're asking. So, next slide, please. So when you're requesting reconsideration, what you want to do is you want to file a fair hearing request if possible. So the fair hearing request is the time limit for that is 30 days, where reconsideration is 90. So if you're outside of that 30 days, you're not going to be able to file a fair hearing request. But if you can do it timely, it's an easier way to keep the benefits intact, as well as get a date of a time like where somebody is definitely going to talk. But if that can't be done, that's okay, because the reconsideration time period is longer than fair hearing. So Again, you're going to want to review that notice that comes with the termination and find exactly what they're saying is missing. Sometimes not every document needs to be updated every year, but a lot do. So they should be listed on there. And if there's not, if the documents they're asking for are not listed on the notice, that's an ineffective notice, which we'll get into in a little bit. So if the documents were submitted, but you still get a termination, now we know that the county assistant's office is going to be inundated with a ton of documents during this time. I'm sure there are going to be mistakes. We've never had to do this before. So just, again, I think Pam touched on this, but patience is kind of key here. If they were submitted and the documents and the client hasn't been terminated or has been terminated, but it's not like an emergency right now, as we're talking about, you know, those Medicaid benefits will be turned back on eventually. Give them some time to reconsider these documents. Now you can check your compass, the participant can check their compass, or if it's a provider or advocate working with somebody, make sure you check EVS to see if benefits have been reinstated. Now you're gonna have to, like I said, allow additional time here, guys, because there's going to be so many of these going on at one time. So we're hoping that it will be handled timely, but again, extra time here is going to be helpful. So when you're talking about, though, if somebody has lost their benefits and needs them now, or like their provider won't see them because they're technically not on Medicaid, that's when you contact the county assistant's office or the customer service center to try to get it done quicker. Next slide, please. So when you're requesting reconsideration, here's the things that you wanted to do, right? So I think somebody talked about it in the chat. You want to have a cover letter and, if possible, have the record number, all that thing on all the documents you're sending. Again, we're really beating this point here, but you're going to have to allow some time for processing. Even now, before the PHE, it takes some time, so we can only assume that it's going to take longer when this happens. So, and once, if you were able to file the fair hearing, make sure that you withdraw it if the issue becomes resolved. And I'll get into more fair hearings in the next stage here, but I wanted to do this. I wanted to plug here our requesting reconsideration toolkit, which is a link there. We will be sending out these documents afterwards too, but it's just a good guide that you can share far and wide to hopefully reduce the amount of calls that we're getting, because a lot of this can be done without an advocate, right? We're not doing a whole lot of legal legwork here. So.
Yeah. And that reconsideration toolkit that we've got a link to, it even includes like a ready-made cover sheet that you just have to fill out. So that just, yeah, just want to plug that too.
I think you got a heart for that, Pam. So, okay, great. So we just want to like plug as much of these self-help materials as you can, as all of us in this line of work are going to be very busy over the coming months. So as much as people can help themselves, or if you believe that they can do this on their own, push for that. Next slide, please. So I'm going to talk a little bit today about the fair hearings. So the fair hearings are what's going to happen, hopefully, if recon, the issue can't be solved by recon. So on this slide here, I just have a little bit of the process, right? So you're going to file the appeal, and I'll get to the time frame to consider here shortly. And you want to keep proof of mailing. Like when you send in the appeal, I always, if the person is able to, I always have them do it certified mail, just so that you can keep the dates, because sometimes the dates, which we'll talk about continued benefits and things like that, are very important. So prior to the hearing, you also have a pre-hearing conference. Now, if during your time when you're trying to resolve this, you can't get a hold of anybody at the county assistant's office at all, right? This may be your only time for the opportunity to show them with as much, law, paperwork, whatever you have, to settle this case prior to the hearing. If that can't happen, you'll have the hearing in front of the ALJ, which is administrative law judge. And then within 90 days of filing the appeal, you will need to get a written decision. And we'll talk about in these upcoming slides what happens if you don't have one within 90 days, because we are not sure how close they'll be able to keep to these timelines. There's a lot we don't know right now when it comes to these timelines, but this is how it's supposed to work according to statutes and according to the hearing. So next slide, please. So what I want to talk about is filing the appeal. Now this is for a fair hearing, right? So you can file them. You hand delivered, certified mail. I always say certified mail, right? But email, fax, you can do more than one as well. I just try to keep it just try to keep it where we have proof of mailing, because as I'm going to get into, these dates can be really really important. And when it comes to like aid paid pending, or keeping the benefits intact, if you have a contact at the county assistance office, call them, leave them a message. Even if they don't call you back, you can say that I left you a message on this date, and then you can attempt to resolve it immediately, right? If this is like a missing documentation case, if there is something that you can show that the termination was inaccurate, or not a correct termination, you can attempt to resolve that. There's no time limit to do that, which I'll get into shortly. But it's just like, we want to say that most of these appeals get resolved without having that, is what we were trying to do here. So on the next slide, please, Pam, we'll talk about the important time frame. So what I was saying earlier is 30 days is the time the client has to file an appeal from the date of the termination. So I have the site there for the handbook and the PA code about the time limits. Now, if they don't get notice, you usually have up to 6 months to file, and that would give them time to find out that their Medicaid is turned off, whether or not they went to a doctor's appointment, a pharmacy, and they were told that their Medicaid is off. This is a way to get around that 30-day time limit, but this may need some advocacy with the county assistance office. You'll have to tell them why that they couldn't file in 30 days. No notice is a good reason, or if the agency sent the termination letter and the termination letter was incorrect. So.
And sorry, Jake, did you say the 30 days runs from the termination or the termination notice?
The termination notice. So 15 days here is, and we talked about 30 days during the public health emergency. This was so that you could get aid paid pending or the benefits continuing. So if you get a termination notice, you have 15 days normally to file the appeal to keep those benefits on pending the appeal. Now, this is when the county assistance office, as we were talking about, is terminating these Medicaid benefits. To keep them on, you would need to appeal soon. So on the next slide here, we talk about the 90 days and immediately. So the 90 days here is what I talked about, touched on before, is the time the state has to schedule and hold the fair hearing, as well as issue a written decision. It runs from the date of the appeal. And now you'll see the last box there is request interim assistance if not decided timely. I have a code site there. What that means is if you don't get a decision within 90 days and the client's Medicaid was turned off at this time, you can request interim assistance, which means that they would have to turn the Medicaid back on until there is a decision, if it's over 90 days. So we're talking about if the hearing happens and then 90 days run and you still don't have a decision, until you have a decision, from 90 days until you have that decision, you should be requesting interim assistance, which means they return the Medicaid back on during that time, pending the decision. And we can talk a little bit more about that if you have questions. It can be a little finicky, and you will probably have to reach out to the county assistance office to read this. Also, I just want to put in there immediately, because that's what I wanted to say. Like, most of these times, you don't have to wait until these timeframes or wait till the hearing. If there's missing documentation, get it to them, right? And I have some strategies in the next couple of slides about ways to do this. You don't need to wait for that pre-hearing conference, but as we all know, and how we have talked about this all day today, is that the county assistance offices are going to be overwhelmed by this time. So it may be that if a client has aid paid pending and there's no rush on anything, you just can't get through, like on a couple of times you try to get to the county assistance office, then wait till the pre-hearing conference if it's not going to. Next slide, please. So in the expedited appeals, now I keep this slide in here because it's important to know that this is an option, right? So 7 days is for an expedited appeal, and the Bureau of Hearings and Appeals, who handles these, interprets these 7 days pretty loosely. But if somebody has had their Medicaid terminated for one reason or another, and it's a medical emergency that they turn this appeal back on, or turn the Medicaid back on, I'm sorry, you can file what's called an expedited appeal. And they have 7 days to schedule, hold a fair hearing, and issue a written decision. Now, again, I want to reiterate here that this is when there's a medical emergency and the county assistance office isn't responding to your outreach, right? Because this is, it's rare to have these granted. It's especially if the client has benefits, and it's almost never going to be approved. But you also have to realize that if the client is going, like if it's like a paperwork or reconsideration issue, the client is going to get retroactive coverage to the date back. So that's not always a medical emergency either. You're going to have like a doctor's letter, things like that, things that show that this client, and I have the box right there, would jeopardize life, health, or ability to attain, maintain, or regain maximum function. So it's kind of a high bar, but I wanted to keep this slide in there because it's important to know that this is an option if, it meets this extreme circumstance. So, and again, if you have questions about that, I'd be happy to answer them. I just want everybody to know that like it's a high bar to get an expedited appeal through this process. So next slide, please. Thank you. So I wanted to do some strategies that we do here at PHLP to help hopefully resolve the issues. And like I said, I'm going to say upwards of 95% of our cases, when we have these kind of issues, can be sorted out before the hearing. So most of the time it's a documentation issue, right? So you want to make it as easy as possible when this county assistance offices are going to be overwhelmed to fix the problem. So what we're talking about is submit, or oftentimes resubmit, because you already did submit the documentation, they just can't find it. Submit that missing information with the appeal. And again, it doesn't matter if it's late, reconsideration, they have 90 days, right? So you want to cite any rules you can in the Medicaid handbook, and just put this all in the original outreach to the county assistance office, right? You want to make it as easy for them, keep it concise, and tell them why you think that this termination was incorrect. And if you need to, don't hesitate to go to a supervisor. If you have the contact information, the statewide number, all the things that you can do to speed these up, feel free to do so, especially when there's a medical emergency. If there's not a medical emergency and we said it and benefits are in place, you may want to take the more patient wait and see approach. But we would, say take your time on that. Next slide, please. So what you want to do as well is you want to humanize your client, right? These county assistance officer or office workers are seeing thousands of cases, right? And it's just a name, number, these kind of things that they're seeing. So if you have information, especially if you're trying to get something resolved quickly, like what your client can't access because of their Medicaid being turned off, or their medications, these kind of things, or like the narrative is the power here too, because if you can appeal to somebody's like kindness or sense of worth, it may help you get these things done quicker, especially if it is a serious medical emergency. And again, when I talk about bad notices, or when Pam was talking about missing like an old address, that's not the only time a bad notice argument can be. Sometimes the county assistance office will send them a notice that doesn't make any sense. So we want to use that if needed. Sometimes you don't need to make a notice argument if you can just fix what the issue is. But sometimes, how can you know what the issue is if the notice was incoherent? So what you'll do is just like, that would be another thing to review. And I attached the PA code there to show you exactly what the notice is required to have. And then there's the mail 15 days in advance. That's for the hearing. So you just want to make sure that you just keep that in mind when you're making a notice argument. Next slide, please. So let's talk about what the fair hearing consists of. So we're talking about, this is your opportunity to be heard, especially if you've been trying to get through the county assistance office and they haven't been responding, those type of things. This is your opportunity that there's going to be somebody from the state there. There's going to be an ALJ there. These are the time periods to do and present your case. So you have like these rights to present evidence, cross-examine the agency, have a neutral decision maker. They're all enshrined in law. And I wanted to just give you guys a slide to show you where they all, in case you need that. And it's just helpful to understand, like, this is a right for anybody whose benefits are being. But before you get to the fair hearing, you're going to have the opportunity for a pre-hearing conference, usually the day of. And what we want to talk about is, like, the ALJ wants to have these cases settled, right? They don't want to go through a full hearing if this termination was incorrect or if there's just a missing document. So they're going to allow you time to talk this out and hopefully settle it. So you want to discuss what you've brought to the case, right? So if you brought the missing documentation, obviously you're going to bring that up. If you brought law that shows the termination was incorrect, you want to talk about that. And you just kind of want to see where they think the termination is correct, right? Where they think it's justified, and then you show them that it's not. And then you should be able to reach an agreement. And again, the agencies, DHS, these kind of things, like, they're not going to want to have these hearings too, especially if they made a mistake. So this is a good chance to settle, especially if you haven't been able to get in touch with anybody. So I just want to, like, have their, like, the agreements and stipulations entered into at the pre-hearing conference are binding, right? So if they agree and then later send out another termination that is based on the same issue because they didn't fix it in their system, this pre-hearing conference agreement or settlement is, just wanted to keep that in mind. So what happens if you can't get that pre-hearing conference settled? So then you're going to have the fair hearing. Thank you, Pam. So what it is you're going to have the administrative law judge from DHS, and you can participate by phone, in person, or video conference. So what you have here is you're going to have DHS and CAO, and they're going to present their case first, why your client is ineligible for Medicaid, which is what we're talking about today. And then the appellant, you, the participant, those kind of things, will have the opportunity to cross-examine, present evidence, witnesses of their own, and to have advance notice of what the county assistance office is using to make this determination. And it's an important reminder here that the burden is on the county assistance office. They have to show that the client no longer is eligible for Medicaid, not the other way around. So these are governed by this code here. Just, I always want to keep these sites here, especially if you just want to familiarize yourself with the process. And as you're going through, it makes it easy to have that site there. And again, the decision is within 90 days of the hearing request. Again, if you don't get it, if you don't have the decision within 90 days, which may happen with how many of these that they may be doing, you can ask for interim assistance. Next slide, please, Pam. So what I wanted to talk to you guys about on just what the juris rule is. And the juris was a case back in 1983. And what it boils down to is that Medicaid benefits will be retroactive to the date of termination if the missing documents are provided after that termination. So it's pretty much to know that if somebody's terminated of Medicaid and it's an incorrect termination, it's later found out, say at the fair hearing or a pre-hearing conference or something like that, that they should not have been terminated, that they continue to qualify, there was just some missing documentation or stuff like that. The juris rule means that the Medicaid benefits go retroactively back to the date of termination. So there won't be any gap in coverage. If these people have medical bills or other, other expenses that they've incurred that Medicaid would have covered, then these are going to be retroactive back and they can get paid back that way. So they should have no longer medical bills. This is an important thing to reiterate. It's also an important thing to keep in mind when somebody's asking whether or not they can continue getting the coverage while their benefits are in flux during this time if they missed a renewal. So now I'm going to take some time for questions about the fair hearing and recon process. And let me
Thanks,
know.
Jake. We have a few questions. The first one is, how do you withdraw a fair hearing request?
So you'll contact the BHA for that. Now, whichever office that's sent in, you can contact them. You will be getting a scheduling notice, and you can wait till you receive that scheduling notice to withdraw. But you can also call in the meantime. But most of the time, it's going to have to be either done by the participant themselves, who's listed on the notice, or if it's an advocate doing it, they need to enter their appearance first.
Okay, can you just say what that means, entering your appearance?
Sure. Sorry, for any non-attorney advocates out there, when entering your appearance is sending in a letter to the Bureau of Hearings and Appeals that you are representing the client in that appeal. The client can also put your name down as a representative on the form, which usually can negate that, having to do that. But I always do it because sometimes clients will put your name down when they've talked to you once. So you just want to make sure, like, if you are representing the client, you'll want to enter your appearance by submitting a letter of intent to represent the Bureau of Hearings.
Thanks, Jake.
Sure.
Are hearings always in person, or can they be done via Zoom?
Yes, they can be done via Zoom, via phone, with whichever. They're actually more likely done over the phone these days than in person. They're rarely done in person, but it's still your right to request in person if you.
Okay. Last question we have here right now, are pre-hearing conferences done in person or virtually?
Usually done however the hearing is going to be done, right? We're talking the same day and time, usually just done before the hearing. So if your hearing is in person, the pre-hearing conference will likely be in person. But as I stated earlier, most of them are done via phone now. So your pre-hearing conference will be done via phone.
Yeah, and just to tag on to that, what often will happen is once the judge has everybody on the line for the scheduled hearing, they'll ask if the parties had an opportunity for a pre-hearing conference. And this is where you can say, actually, no, we didn't, and we'd like a chance to talk to the county assistant's office about that. And then the judge will go get themselves a cup of coffee, give you guys a few minutes to have a conversation.
Thanks, Pam. And I just wanted to return to one question that came in during the first portion from Peter at PA Medi. He asked about whether the process is the same for beneficiaries who are enrolled in PA Life. And I looked into that, and the county assistance offices do handle the eligibility, the financial eligibility for PA Life. So those folks would be getting the same kind of renewal packet. If they are terminated, they'll get the termination notice. And then if they need to appeal, it's the same fair hearing process.
Great. Thank you, Dana.
Sure. Oh, and then we did just get one more before we move on. Are there any consequences if a hearing is not scheduled within 90 days of an appeal due to an error or delay by the CAO?
Yeah, I mean, so like I was using it as we don't have a decision back and you can request interim assistance, but if the whole hearing hasn't been scheduled and you can request interim assistance, it becomes a little sticky. And Pam, you can like expand on this if you want. If your client, like the participant, is requesting continuances, the interim assistance may not be granted. But if it's been over 90 days without any fault of your own client, then they are eligible for interim assistance.
Thank
Right.
you, Jake.
Yeah. What Jake was saying, yeah, the remedy in that case for the participant is to get interim assistance and get the benefits on while they wait for the hearings or the appeals office or the county to catch up.
Great. Okay, those are all the questions we have for right now. Thank you both.
Okay, thank you. I'm just going to talk a little bit about the resources we have here and just highlight some upcoming webinars we have. I'm also going to have Pam and I's contact information here on the last slide, as well as I think I answered a question earlier with our staff email. So if you can always reach out directly to us or reach out to our staff. We may send you to the helpline if it's something that needs to be handled through that, or if it's, a question, we can hopefully help you that way. So the first people we're contacting here for help is DHS customer service, right? We've heard how hard it is to contact the county assistance offices in normal times. And I think both Pam and I have beat that horse to death today, but we just want to be sure that you know that They do have a statewide customer service center. Philadelphia has their own, as Philadelphia normally has their own things going on. But so we just want to keep those numbers here as a thought process, like just like use this as a list of things to go through when you're thinking about it. So then there's us, right? We have our helpline, and we're open. Our helpline is open Mondays and Wednesdays, 8 a.m. to 8 p.m. And you'll just leave a message, and our intake staff will return the call. You can also email us at staff@phlp.org. And hopefully, like, not only county assistance offices, we're going to be dealing with a lot of cases, but if it's something that you can't figure out on your own, definitely reach out to us. We're happy to help. The same with, we're going to plug the Pennsylvania Health Access Network FAN here. They also have a helpline and an email there that you can contact them as well. And then the local legal aids also do and can help with some Medicaid, and especially if you have other public benefits work like SNAP and other things like that, LIHEAP, you're going to want to contact your local legal aid, because at PHLP, we only help with Medicaid, just letting you know. So if it's something outside of that, or like kind of wrapped into two, maybe consider your local legal aid. And we just have a note there, right? So it's a busy time for everybody. So we will try to get back to you as soon as we can. We are working, all systems go here, but it's going to be a little touch and go there for a little bit. So give us as much patience as hopefully you'll give the county assistance offices. So just some helpful resources here for you to have, right? So we have the Medicaid handbook, the supplemental handbook as well. We have some unwinding toolkits from DHS specifically. And then you heard Pam talk about the ops memos, and here they are linked. Just kind of like, this is something to go back to when you're seeing whether or not the termination is correct, right? If it's over income, but you think they should have been terminated during a time, like this is where you should go. Just to keep them all in one place for you. So
yeah. And just to add to that, like the medical assistance eligibility handbook is really a go-to resource if you're trying to figure out if someone's eligible, and you're trying to figure out, wait, does this count as a resource for PH95? All of those ins and outs and what have yous are usually in the medical assistance eligibility handbook. And they also have a lot of policy clarifications and ops memos there, elaborating on some finer points. So I just wanted to explain more about what you'll find there.
Yeah, and they also have helpful examples as well. Like they'll give you just hypotheticals so that you can understand, like, how these resources and how these rules are in practice too. It's not the most visually pleasing read, but it is very helpful, and we still use it daily here at PHLP. So
yeah. And more importantly, you can cite to it when you're dealing with the county assistance office to say, see here, it says here that it doesn't count, this doesn't count, or that they should be eligible. So
here's just our resources, right? We had touched upon our Recon toolkit, and we do a lot of these self-help materials because we just don't have the staff to handle everything that comes our way. So if you have people who you think can help themselves, or if you want to give yourself like a refresher, you can always keep these things, right? I saw that subscribing to the newsletter was a question, so we have that here in the slide. We have the older Unwinding webinar series, and then on the next slide, I'll get into the upcoming ones here for you. So the upcoming ones here, we have Revisiting MAUD and Introducing the Workers with Job Success Program. So just briefly, without getting too much into MAUD or anything, like there are people who would be eligible for MAUD but haven't been moved into MAUD because of the public health emergency. So that's also going to be a switch. So if you have people that that are over income and worried about losing their Medicaid, then definitely register for our MAUD webinar, because it is a kind of a little known category of Medicaid with much higher income. And then we also have, and I mentioned it in the chat earlier, but the dual eligible in the Medicare savings program, what comes with the enrollment periods and things like that. We will touch on that on May 17th. But other than that, our last slide here is both of Pam and I's contact information, as well as our helpline, social media, all those things that we have here for us. So feel free to reach out to us directly. We may end up sending you to the helpline if it's something that needs to have an open case, but you, especially if it has to do with appeals, fair hearings, reconsideration, feel free to reach out to Pam and I directly. And I appreciate everybody's work here today. And I know that we are in for a busy year, I guess is the nicest way to say it. So the help that you guys can give and that hopefully we can give to you and your clients. I would, I thank you guys for the help and I hope that this was helpful for you.
Thank you, Jake and Pam. And thanks everyone for joining today. I hope we see you on our next webinars coming up in the next month or two. Have a great day.